No, I wouldn't do that.
Before we get started in chapter 9, let's talk a little bit about chapter 8. So without looking in your book, who can tell me, who remembers what the divisions of things are? Article 448. Public and private.
Common and
Actually, common is part of public and private. It's common, public, private, and you're on track. Movable and immovable, right? Okay. Give me an example of something that's incorporeal. Stocks, yeah. Now, sometimes those are a little tricky because sometimes people actually have a stock certificate, and the certificate itself is corporeal because there's a certificate associated with it. But what the certificate represents is incorporeal, that right to a business interest. And in theory, you could misplace the certificate and still have the right. So that's the reason why stock is going to be considered an incorporeal. Give me an example of a movable. A movable. Car. What about a mobile home on a piece of property?
Are the wheels off of it?
Are the wheels off of it? Yeah, the wheels are off of it. All right, settle down, settle down. All right, so we've got so that brings up a really good point. We're talking about physical immobilization. We're talking about removing the wheels and anchoring to the ground. What they're really talking about in the book is legal immobilization, which is this concept of filing an affidavit declaring something immovable so that you can get the benefit of the immovable status, homestead exemption, homeowner's insurance. Because the reality is I could jack that sucker up, put the wheels back on, and take it off. So it might be immovable physically, but it's not necessarily immovable legally. And I think that if I was going to test you on how savvy you were about that particular topic, that would be the example I would give you. I would want to see if you could distinguish between the physical immobilization and the legal immobilization. You may remember what just title is? What's just title a part of? You might remember what just title is a part of? Levette?
No, I don't remember anything.
What? Just title is an element of acquisitive prescription. What's acquisitive prescription? Give me the common law term for acquisitive prescription.
Statute of limitations.
Statute of limitations. So just title is an element of good faith acquisitive prescription. This idea that if I have title to a piece of property, and I'm in good faith, I believe it's my property, and then I possess that property for 10 years, I've got a claim for statute of limitation. I've got a claim for acquisitive prescription on that. Bad faith acquisitive prescription, which is the more traditionally referred to as squatter's rights, is this idea that I have no documentation indicating that I'm the owner, so I have no just title. I don't have good faith. I don't believe that I own the property because I've got no documentation that supports I own the property. And then I've got 30 years of possession. That's the other idea. All right, so let's roll into chapter 9. Chapter 9 is a long chapter, servitudes, and it's by far the most interesting part of the law, servitudes or not. But I think something that servitudes does is it encompasses a lot of things you probably don't associate with servitudes. I know that when I hear the word servitudes, the first thing I think of is the driveway that I have to cross to get to my neighbor's property. But the reality is the first part of servitudes isn't about that kind of stuff at all. It's about personal servitudes. And so it says on page 94, it says at the very top, a servitude is a charge or a burden upon a thing, usually an immovable for the benefit of another person or another estate. Black's Law Dictionary, 6th edition, 1990. It is closely related to the common law concept of easement. All right, so this chapter is broken down into two kinds of servitudes. There are either personal servitudes or there are predial servitudes, and you do need to be able to distinguish between the two. It says a personal servitude is a charge on a thing for the benefit of a particular person and terminates with his life. Doesn't that make sense? Personal servitude is for the benefit of a person. And a predial servitude is a charge on a thing for the benefit of the owner of another thing. A predial servitude is often what we're associating traditionally with easements, this idea that it's an access across someone's property to be able to access a piece of property that I own. A predial servitude does not terminate with the death of the owner of the thing in whose favor the servitude runs, but extends to any owner, whether the original or a successor. I just did a closing. It ended a half an hour ago where a person bought a piece of property and they have to access their property through a personal servitude. If that servitude were to cease to exist when the person that bought the property died, that property would be of no value to anyone else. So servitudes related to access run in perpetuity because they run with the property. So that anyone who owns the property gets the benefit of that servitude. Does that make sense?
So did the owner of the personal servitude turn it into a predial servitude?
I don't think it was ever a personal servitude. I think from the moment it was created, it was a predial servitude. It was
Recorded with the deed?
It was recorded with a deed. It's a 20-acre tract of land. It was all family property in Pearl River. Each person owned a little piece of it. Do you know about this transaction? Your name was mentioned in the closing. Donna, you know?
Don't you remember that lovely transaction we had last spring?
Mm-hmm. Yeah. No?
I'm trying to remember, their last name. It was on Peashaw Road.
Okay. We had an access issue in it?
No, we did not have an access issue. We had some other issues, title issues, because it was part of a big tract of land that a big family
A
owned.
lot of times that's the case. A lot of times.
My name was mentioned, though. I hope it was good.
Oh, it was good. It was good. It was a closing the day. Your name was mentioned in the closing. The agent just asked me if I knew. Yes, sure, I don't know. But I thought that maybe you were involved in it. You just couldn't be there this afternoon.
Yeah.
All right. So typically, what happens with large family tracts of land is that because it's family, things aren't always done by the book. It's family. And so a lot of times when you're dealing with tracts of land involving family, you'll run across those kinds of issues. In this particular circumstance, we just had a large tract of land. The family's done everything right. They've cut in roads, and they've actually got the roads designated with street names that are not related to the family, and they've created servitudes for access so that people can buy the property freely and be able to access the parcels that they're buying. And the good thing is that they did all this more than 10 years ago before the parish started to regulate that activity. I don't know how it is in Orleans or Jefferson Parish or in Tangipahoa Parish or any other parish that we might live in and do business in, but in St. Tammany Parish, servitudes for the purposes of creating parcels of land are regulated by our planning department. You just can't cut in a servitude unless planning says it's okay. In this particular case, all these servitudes existed before planning was involved, and so we had a servitude in our closing so that this person could access their property. That's a predial servitude, something that's going to run for the benefit of the property, not for the benefit of any individual. All right, so I'm going to skip the articles 533, 534, 646. They essentially just repeat what we just read in that previous paragraph. And then it says 733 and 734 I think are kind of important. It says when the right granted be of a nature to confer an advantage on an estate, it is presumed to be a predial servitude. When the right granted is merely for the convenience of a person, it is not considered to be a predial servitude unless it is acquired by a person as an owner of an estate for himself, his heirs, and assigns. So kind of, Lorraine, that kind of goes back to your question. If I had bought that property and the servitude was in my favor, but it was supposed to run in favor of my heirs, successors, or assigns, that's a personal servitude that has predial type effects because it runs in favor of all the successors to me. All right, in the personal servitude category on top of page 95, there are three types of personal servitudes: usufruct, habitation, and right of use. Who remembers what the three parts of usufruct were? Lindsay, you remember the three parts? Usus? Uh-huh.
That's all I got.
That's all you got? Who's got the third?
Abuses.
Abuses. Usus, fructus, abusus. Usus, the right to use. Fructus, the right to the fruits. Abusus is the right to alienate. And in order to be able to be considered an owner, a full owner of a piece of property, you've got to have all three elements of those. All right. So it says usufruct is a right of limited duration on the property of another. Usufruct is an incorporeal thing. It is movable or immovable according to the nature of the thing that is burdened by the usufruct. So the usufruct of a house is what? Would it be an incorporeal, immovable?
Yeah.
What about the usufruct of a car?
Corporate.
I think it's still a usufruct, so I think it's incorporeal, but because it's a usufruct over a movable, it's going to be an incorporeal movable. Okay? All right, so it says in that next paragraph, after we skip 535 and 540, the next paragraph says the usufructuary, that is the person to whom a usufruct is granted, can sell, donate, lease, or encumber his right. Similarly, during the existence of the usufruct, the naked owner may likewise sell or donate his naked ownership, though it will not affect the rights of the usufructuary. Now, I'll be honest with you. In theory, you can do this, but in all practicality, it's not something that happens very often. People don't want to buy the naked ownership in something because we have no earthly idea how long if it's a usufructuary that runs for the lifetime of the usufructuary, we have no earthly idea how long that person might live. And there's an old wives' tale about this lady who sold the naked ownership of her condo in New Orleans, and and then she lived to be 103 years old. You know, so that's kind of the idea, that people don't want that naked ownership because it doesn't represent a lot of value with the variable of when I'll ever be able to use it. People do buy the usufruct. They do that. So let's say Jessica C's got the usufruct of a house and she sells me the usufruct. When does it terminate? Does it terminate at my death or does it terminate at her death? Now, but I bought it from her.
But she can only sell what she has.
That's right. She only sells what he has. So I buy the usufruct from her. My death or her death?
Oh,
Her death.
her death.
Her death. You confident on that, Shannon?
I'm not
I'm
now.
not confident.
Oh, you gotta be confident. Yes. It's absolutely. You can't extend the usufruct by perpetually giving it to younger and younger and younger people. If a usufruct is granted to someone, the usufruct runs for their life. It's the lifetime usufruct.
So that's like
It runs for their life.
That's like the example you gave of the mother who gave the usufruct to her daughter when
Mhm.
her husband had other children.
Right. Actually, that was
me.
Donna's
Somebody-
example.
okay.
Donna had that example where
Okay.
husband and wife go in, they get wills, and on the pretense that when you die, everything gets split amongst our kids, assuming that we have different sets of kids. You've got kids from one marriage, and I've got kids from one marriage, and we want them to have everything equally when we're both done with it. But the wife went in after the husband died and changed her will. And instead of leaving everything to the kids equally, she left everything to her daughter as a usufruct so that her daughter got it until she died. Then all the kids got it. That was the way it was done. That's dirty pool, but that happens. That kind of stuff happens.
Hey, but you know what? You're gonna be closing something the daughter bought to move out of the house.
Well, then then I appreciate her
30
business.
days.
Yeah, I appreciate her business. She's a good client. That's fantastic.
Not the mother, the daughter.
All right, so these things are marketable. They're not practically sold. These are not things you see sold as a practical matter, but this idea that they can be sold. Now, if my dad inherits a piece of property from my mom after she passes, and he's a usufruct, and I'm the naked owner, and I sell my naked ownership to Shanna, are you still burdened by the same rules I was burdened by, or can you not go in there and force him to sell the property to get your half? I see some shaking heads no in the back. No?
You can't.
No. So she doesn't. So the terms and conditions of the naked ownership don't change.
Right.
And I think that's really important that you have an appreciation for that concept. You can buy the naked ownership. You can buy the usufruct. You can negotiate for it as part of an exchange. Someone can even give it to you. But the change in ownership does not change the nature of how it works.
But if he remarries, you go move his ass out. Okay?
You're gonna be haunted, huh?
Put it in the binder, honey, put it in the will.
All right, so we're not going to read, let's read 567 on page 95. The usufructuary may lease, alienate, or encumber his right. All such contracts cease of right at the end of the usufruct. If the usufructuary leases, alienates, or encumbers his right, he is responsible to the naked owner for the abuse that the person with whom he is contracted makes of the property. So Mom and I had a cousin whose husband passed away, and she inherited the usufruct of his separate property. The house they lived in was his house, but he had gone to an attorney or gone to a notary and had a will done where he left his wife, our cousin, the usufruct of the home. And of course, she was the wicked stepmom, and her stepchildren hated her. And they made it very, very, very difficult for her to continue to live in that house. They made it very difficult. She contemplated leasing the house. She contemplated, you know what I'll do? I'll show those kids, I'll put a tenant in here, and I'll move someplace else. So what this says is that she had every right to do that. She can lease that property. But what would have happened if she would have passed away in the middle of that lease?
They would have kicked that person out.
There you go. Sanji is on top of it. So she would have had to have put some sort of stipulation that you can really only lease this house as long as I'm alive. If something happens to me, I can't promise you that the naked owners, who then become the sole owners of this property, will honor the lease. Because the naked ownership relationship would have existed prior to the leasing relationship. Does that make sense?
Even if the lease was recorded.
Even if the lease was recorded, because what was recorded before it? Would have been the usufruct would have been recorded before it. So in the concept of the public records doctrine that we talked about, where things are recorded has their effect on the property. The creation of that usufruct would have been a mechanism of his succession, and it would have been recorded prior to the lease. So recording the lease would have been fine, but it would have been subject to the usufruct. And so therein lies the issue. Ultimately, she relinquishes the usufruct, gives the house back to the wicked stepkids, and just goes about her business. Decided it just wasn't worth it. Didn't put the tenant in the property because she didn't feel like she could put the tenants in that kind of a situation. Okay? All right. Disposition of the naked ownership, alienation, or encumbrance of the property. The naked owner may dispose of the naked ownership, but he cannot thereby affect the usufruct. The naked owner may establish real rights in the property subject to the usufruct, provided that they may be exercised without impairing the usufructuary's rights. Bless you. The naked owner must not interfere with the rights of the usufructuary. Sale of the property or of the usufruct. Top of page 96. Usufruct terminates by the enforcement of encumbrance established upon the property prior to the creation of the usufruct to secure a debt. The usufructuary may have an action against the grantor or the usufruct or against the naked owner under the provisions established in section 3 of this chapter. The judicial sale of the usufruct by creditors of the usufructuary deprives the usufructuary of his enjoyment of the property, but does not terminate the usufruct. What are they talking about there?
Okay.
Makes the enforcement
If
As
they
we said.
use the usufructs as collateral for a debt and then go belly up on the debt. and
So give me the example, the practical example. And I hate to keep using mom and dad here, but it's easy because they're right here. So mom passes away, dad
Dad's got usufructs
usufruct,
of the
and then he
house.
goes to the bank and pledges the house as collateral.
The house is collateral, and
Okay.
then he bellies up on the loan,
Mm-hmm.
and the court sell the house. The usufructs is still in place.
Is that transaction even valid, the way
Yeah,
she described it? Why is it not valid?
Because
the
even
naked
a
owner-
settlement
naked
agreement
Would lend you money on a usufruct.
There you go, there you go. So we're all on the
They're not
same
gonna do
page.
it.
That transaction's not gonna work, because in your example, the naked owners didn't come in and pledge their interest in the property. There's not a
Yeah,
bank in
right.
town gonna make that loan.
Right.
So if they made a loan and he dies, and then the naked owner comes up and says, I'm not paying that, he got that money, so then the house goes in foreclosure.
This is what they're talking about. You're scratching the surface of this. We're talking about mom and dad have a loan before either one of them passes away. It's imperative that as part of the statute that you understand that the mortgage that we're talking about existed before the creation of the usufruct. Because it goes back to the public records doctrine, what Dina was just talking about. Where things fall in the public records determines where their importance is in the nature of the transaction. So in that example, mom and dad have a house, mom and dad have a mortgage on the house, mom passes away. Dad is the usufructuary. Dad says, hey, I'm the usufruct, I'm not gonna pay this bill anymore. He stops paying the note. The bank is not impeded by the usufruct because their mortgage existed before the usufruct was created. The bank is to say, hey, dude, we don't care if you got usufruct or not, we're foreclosing. And they foreclose on the property. The idea that the usufruct survives is this idea that if there was anything else for which he had a usufruct over, let's say he had a usufruct over the car, he had a usufruct over the checking account, well then the usufruct survives as to everything else. The foreclosure as to the property that the usufruct existed does not terminate the usufruct across the board. It terminates the usufruct as of that property or to that property. Okay? So the critical part of that scenario, and if you're tested on this material, is recognizing where the encumbrance that's creating the basis for your question is coming from in relationship to everything else that's on title to the property. Okay?
So the naked owner is, no, right, the naked owner is still, no, the dad is still on the line for the property.
Mm-hmm. Dad's the one that signed the
Because it was
promissory
before the
note.
use of property.
That's exactly right. So let me ask you, you kind of bring up a really good point. So Dad stops paying the bill. Do they call me up and say, Ray, as a naked owner, you gotta pay?
Nope, they put him out.
What do you think? Don't let Robin change your mind. What do you think?
Wait a minute. So say that again?
Okay, so in the example we've been talking about, sorry, mom passes
I know.
away.
I'm always dying.
He stops paying the note. I'm the naked owner. I've got two brothers. The three of us are the naked owners of the house. Does the bank call me up and say, Ray, you gotta make the monthly
I
payments now?
think yes. You're the naked owner?
I'm a naked owner.
Yeah.
They do?
Because you
Who
own
agrees
the
with these
house.
ladies up front?
Well, wait, you own interest in the house?
Uh-huh.
I would say yes.
So I think when we
The
go
mortgage
back
was
on-
before.
I think the bank don't call anybody.
Before-
Yeah, they don't.
Well, look, Dina,
want
that's a
payment.
good point.
They want payment.
Look, that's a good point, and if that's the basis for your answer, then you're right. By all means, the bank's gonna call people and say, you need to pay this money.
Somebody.
But I am not legally responsible for making the payments because I never signed a promissory note promising to pay that loan back. We're gonna find as we move this material, technically I have what they call an in-rem liability or an in-rem status with this property, which means that they're gonna call me and say, Ray, you need to make the monthly payments. Not you have to make the monthly payments, but you need to. Because if your dad defaults,
You're gonna lose that.
it's going to lose the house, and you're going to lose your interest in the house that goes along with it. Now, look, they might say you have to. What they're supposed to say is you need to,
We're
you
giving you
should,
the opportunity.
or you stand to lose your interest in the property. But they can't say you are legally responsible, because I'm not. I never signed that promissory note.
widows and widowers frequently, and
What?
the banks don't, they don't care.
No,
They
want
just
them
want
to-
a business
Yeah.
transaction.
it's, well, absolutely, Patty's right, it's a business
It's
transaction.
very sad, but very real.
Now, I think this next part is really, really interesting stuff. So let's read 616 and 617. We're going to start with the paragraph in front of it, though. When the usufructuary sells or otherwise disposes of the property, or if it is destroyed, the usufruct transfers to the proceeds derived from the sale or the insurance. That's Civil Articles 616 and 617. We're on page 96. We're like the second or third paragraph from the top. So let's talk about this. Dad passes away. Mom has the house. I'm the naked owner. Mom says, this house is too big for me. I can't do it. I'm gonna go hire Donna and Rob, and they're gonna help me find a new place. We're gonna downsize it. Patty's got a nice little listing. It's a smaller house. So she comes to me and she says, look, I want to sell the house and I want to use the proceeds to buy the new house. Is everything okay with this transaction so far?
Well,
What's that?
Her proceeds.
What do you mean her proceeds?
whatever her share of the house is.
Okay.
Whatever Dad didn't leave to you.
Look, okay, all right. So she can do this transaction with or without me. Is that what you're suggesting? With me? With me. But she gets her portion of the proceeds. What happens? So let's say in this example, she owns half the house. I own half the house in naked ownership. She has a usufruct over my half. Now look, Patty's house is nice, but she's going to need more than just her half of the house to buy it. So she needs.
You better give her that money, you'll never sleep at night.
We're not talking about the moral implications of what's going on. But I want to talk
He's
about
over 24, all right?
what's legally taking place there. So the usufruct attaches to the proceeds, right?
To hers.
Right. To her. The usufruct attaches to the proceeds of the portion she has a usufruct over. In this example, she has a house. Half that house is hers. Half that house is Dad's. Dad passes away without a will. It's important that we establish it's without a will to make this example work. I have two brothers. The three of us come to each own 1/6 of that house. 1/2, 1/3 times 1/2. Mom has a usufruct over our half of the house. She needs more than half of the proceeds of the sale of her house to buy Patty's listing.
Y'all have to sign it.
We have to sign it.
Well, you don't have to, but you
She
can.
still has usufruct
We will
over
be
your
looking for
proceeds.
you to put your John Henry.
Is then, I mean, just kind of like a minor's mortgage, I know you're not a minor, but would your naked ownership be protected?
Let's talk about that. We're going to go a paragraph ahead and we're going to talk about that. So it's important, it says consumable things. I'm on the bottom of page 96. Consumable things are those that cannot be used without being expended or consumed or without their substance being changed, such as money, harvested, agricultural products, stocks of merchandise, foodstuffs, and beverages. Now, it says non-consumable things are those that may be used without alteration of their substance or without being consumed or expended. This is true even if the thing may be diminished or deteriorated naturally by the passage of time or normal wear and tear in its use. Examples of non-consumable things include land, houses, animals, food, furniture, and cars. All right, now let's go to page 97, the paragraph right below that article. It says, if the things subject to the usufruct are consumables, the usufruct becomes the owner of them. He may consume, alienate, or encumber them as he sees fit. At the termination of the usufruct, he is bound either to pay the naked owner the value of the thing at the commencement of the usufruct, or to deliver him things of the same quantity and quality.
At the commencement.
At the
So
commencement.
what they were worth when
It started.
the usufruct started.
Now, what I wanted to kind of bring to your attention as part of this example is that the difference between a usufruct over something consumable versus a usufruct over something non-consumable. So the usufruct, while it exists over the house, is fine. My interest in the house is protected because it's a non-consumable thing. But the moment that my interest in that house gets reduced to cash, so after they do their closing, but before they can buy the house that Patty's got the listing
To
on,
establish that value.
she could actually consume that cash because she is the owner of that cash as an operation of law. Do y'all see the difference?
Yeah.
But what?
We're not talking about morals, Donna.
No, I'm not talking about
I'm not talking about morals. And maybe I should know this, and if I embarrass myself, I'm gonna apologize ahead of time. Okay, so I send, your mom's agent,
Right?
and I send the contract to Patriot Title, and
Mm-hmm.
they're gonna go in the court records to research,
Mhm.
correct? And they're gonna find out that there's actually other owners.
Yes.
And the title company's gonna make sure that the owner is either signed to, I don't know what the legal term is. I've been part of this at
Would
one
y'all
time.
be calling
No,
for an
like-
amendment?
Like donate back to your mom your interest.
That's your recommendation, that I give my mom the interest in the house?
I'm just saying you could.
Oh, yes.
Quit claim.
But then if I give her my interest in the house,
Whatever you're gonna do.
I give her my interest in the house. Now,
Yeah.
listen, I'm with you, and I'm not suggesting that's wrong. But let's run that scenario
Okay,
through.
alright.
I quit claim my interest in the house to her. She says thank you very much. She meets another guy, and she gets
Before I close the sale,
she meets another guy, and she decides that this new guy is better than the last guy, and she wants to leave everything she's got to the new guy. I'm not guaranteed to get my stuff back.
But that's the law.
What's the law?
Okay, if you were to quit
Wait, don't
claim.
you spell?
No, yeah, exactly. My question is, why am I quit claiming? I agree that was the scenario that was proposed.
okay.
No, okay, Sandra, we're back to talking about the morality of the transaction, but I'm talking about the practicality of it.
Don't y'all have
I'm
to
not
be
talking about
involved?
So in other words, he's not quit claiming.
What if the consumable is a $2,000 bottle of Remy in crystal bottle?
Okay?
She meets this new guy.
Right.
They drink it.
Well,
At the
it-
end of her usufruct, she's got to give you $2,000?
It's an
So-
empty bottle.
No, I hear you, but it was a consumable. So it was a consumable to begin with. Therefore,
Right.
she had the right to consume it. It was hers as an operation of law. What I'm talking about, I had a usufruct. I own a half interest in a house that was a non-consumable. It was protected by virtue of the fact it was non-consumable. She needs to reduce my half of the house to cash to do something else. If I let her reduce it to cash, and I let that usufruct become a usufruct over a consumable, and she decides to blow the cash on something else,
The silver slipper.
the silver slipper. Now Lorraine says, okay, but when she dies, she's got to give it all back to you. How am I guaranteed to
I'm
get
gonna
my
write
money
him a
back?
check.
What's that?
Y'all have to be involved in that transaction.
We sure do. No, there's no question about it. She's not
You're
doing the.
confusing me.
No,
Okay.
she's not doing the transaction that we haven't quite gotten to that point.
Okay.
I just want to kind of work us through this idea
Of
that consumable versus non-consumable and how a usufruct affects both.
I was running it through my head and I'm going, wait a minute.
We're going to see throughout this book, we're going to see about how the usufructos, the naked owner. The problem is that a lot of usufructs terminate at death. And if the person dies with nothing, what value is them owing me anything?
Yeah.
Okay? You okay? Did you give me the rights over there? Were you saying right? That was you? You agree with me? I'm asking, you agree with me?
No, I agree.
Okay.
I mean, if you die, you don't have anything, what can you get?
You can't get bailed out of a term.
Exactly.
Right.
So they're
Okay, but
in.
if she buys the house with the proceeds and you still have,
It attaches.
Exactly. So Robin brings up the point. She wants to know practically how does this transaction work
Right.
out. And so the title company calls me up and they say, hey Ray, your mom's buying this new house and we're going to need you guys to come in and participate in this transaction. And I say, I've got reservations about letting my mom have the usufruct over the cash portion of the proceeds of the house. We're going to need to do something to transfer the proceeds of the sale of this house into the proceeds of something else that is non-consumable that protects my usufruct. I'm not going to stand in the way of mom signing and selling the house. I'm going to have to show up and I'm going to have to sign because I have an ownership interest. I have the...
Y'all have to be part from the beginning.
What part do I have as a naked owner? What's the element that I have?
You
I have
ownership.
I have the abusus.
Yeah.
I have the abusus. You can't sell the property unless you've got
Without
the
your
usus, the fructus, and the abusus. So you can't sell it without me.
Right.
But I want to make sure that the proceeds that get reduced from the sale of this house, that those proceeds go into something else that protects my usufruct. Because if they just transfer the proceeds to the house that Patty has, and the rest of the cash goes into the bank, and she decides to go to the casino and blow it, a CD titled in everybody's name. Yeah, absolutely. That's actually what you see. In a lot of cases, you'll see a CD purchase with the excess proceeds, and it would say Pam Brinson, usufructuary, Ray Brinson, Danny Brinson, Bo Brinson, naked owners. That's how you would see it. And now that CD is still cash, but the title of the CD prevents her from just walking in one day, cashing it out, and taking off the proceeds.
You sign it.
That's exactly right. So you're going to find a lot of naked owners are not comfortable with Dina's suggestion of just transferring title back to her because I'm not guaranteed to get it back. You're going to see a lot of naked owners want to see that usufruct transferred to something else that protects their interest in the new asset just as much as it was protected in the house it was in originally. Okay? All right. All right, usufruct over non-consumable things, Article 539. If the things subject to the usufruct are non-consumables, the usufructuary has the right to possess them and to derive their utility, profits, and advantages that they may produce under the obligation of preserving their substance. He is bound to use them as a prudent administrator and deliver them to the naked owner at the termination of the usufruct. Whether consumable or non-consumable, movable or immovable, the essence of the real right of usufruct is the right to use and possess a thing owned by another and the right to the natural or civil fruits that the thing produces. Let's flip it over. Now what you're finding in this chapter, if you've read it in advance, is that a lot of these code articles are essentially just repeats of what's already in the text. So there's just no reason to kind of go over it. And I'm not touching on everything. When I think if you're going over this material and you want to see how a distribution, corporate distribution is impacted by a usufruct, you can read it right there in Article 552, for example. All right, so it says, page 98, the Civil Code provides special rules for a usufruct over shares of stock and the treatment of civil fruits they may produce. Article 552 and 553 talk about that. Now what's kind of interesting about those two articles, Article 553 says the usufructuary has the right to vote shares of stock in corporations and to vote or exercise similar rights with respect to interests in other juridical persons unless otherwise provided. So as the naked owner with the right of abuses, I have no right to vote the stock. Only the usufructuary does. It says usufruct may be granted to several persons in divided or undivided shares. Both the usufruct and the naked ownership are subject to partition among the various usufructuaries or naked owners as the case may be. We're going to talk about partitions more in chapter 29. So what they're talking about there is that in the example that I gave where my brothers and I all have the naked ownership, we all own 1/3 of the naked ownership. I don't have it solely. My brother doesn't have it solely. We share 1/3 of the naked ownership. So that's going to be like an ownership and indivision of that right. Now, if what we had naked ownership in could be equally divided into 3 parts, what they're saying here is that we could split it up into 3 parts. Okay? Does that make sense? But if it's not, if it's a 1/3 ownership and division in one home that can't be divided into, 1/3 the bedroom, 1/3 the living room, 1/3 the kitchen kind of a thing, it's not going to work. But if it's 3 acres of land, I could take my naked interest in 1 acre, my brother could take naked interest in the 2nd acre, and my third brother could take interest in the 3rd acre. So we wouldn't have to be co-naked owners anymore. We would be naked owners of our respective 1 acre tract. But the usufructuary, the person who has the usufruct of all 3 acres, they're not impeded by our decision to split up our interest. They're not impeded by that. They still have a usufruct over the entirety of the property. Okay?
Got it.
All right. Page 99, a usufruct may be established either by a juridical act during the life of the grantor or by the grantor's express written statement in his last will and testament. It may also arise by operation of law. Where it arises by operation of law, it is called a legal usufruct. Examples of legal usufructs are the usufructs in favor of parents over the property of their minor children, and the usufruct in favor of the surviving spouse over the former community property of a deceased person in an intestate succession. That's a mouthful. The usufruct in favor of the surviving spouse over the former community property of a deceased person in intestate succession. When we were going through the example of the property that my brothers and I inherited, I made it real clear that mom dies without a will. Because if she dies with a will, I happen to know in her will, I'm out. So every dad gets everything. So it doesn't work because in a will, you don't have to leave your kids anything. If they're over the age of 24, they don't otherwise meet the forced heirship definition. You can leave everything to your surviving spouse. And that's more often than not, if you're going to be a notary who's going to do will work for people, if they come in and they've got children over the age of 24 and they're still in their first marriage, 99 times out of 100, they want to leave everything to their surviving spouse and they don't care what they do with it after that. But it requires that their children be over 24 or not be forced. And we'll talk about those terms more when we get to that chapter, but the idea that a person dies intestate, an intestate succession, if we've not covered it yet, that means you die without a will. Okay? A testate succession is where you die with a will. So what they're saying is that if a husband and wife have community property and a husband or a wife pass away, the surviving spouse, the surviving husband or wife, by operation of law, gets usufruct over the community property. that half that the husband or the spouse died with. They get usufruct over it. What happens if they don't have any kids though?
Well, we go to their, over their area.
What's that?
We go to their siblings.
Intestate success. No, I see what you're saying. There's an exception. We'll talk about it. Maybe that's too tricky of a question. There's a part in successions where your community property goes to your spouse. It's your separate property that devolves out to siblings and parents and things of that nature. But a husband and wife who pass away and they have no children of their own, the spouse who passes away without any children intestate, their surviving spouse is going to inherit their community asset. Now what happens, and I'm actually, I think we just lost this file because they couldn't work it out. What happens is that if my wife and I own a house together, but it's not in community, and one of us pass away without children, then because it's not a community asset, my half or the half of the decedent spouse is going to roll out to siblings and it's going to roll out to parents. And so we had a situation where in our title work, somewhere in the mid 80s or 90s, a husband and wife who owned a house here in Slidell got a divorce. But it was one of those paper divorces. They got a divorce so that they could dip into a retirement plan. Because you can't get into your retirement plan until you reach a certain age or unless you're doing it as part of a community property partition. Is that some of the work y'all do, Lindsay? Y'all do that kind of stuff? So they get divorced. As a mechanism of their divorce, their community property gets terminated. Y'all with me so far? I mean, that's what happens. You get divorced. Properties, but they never partition their property outside the retirement plan. That's the only thing that they touched. The only thing that they touched as part of the community property partition was the divestiture of a portion of the retirement plan to the wife as part of the settlement, which I would imagine that they used to pay bills, whatever else the circumstances were. But they never went back to community, and they never, and they did partition the house. They did partition the house. That's part of the example. They did partition it, but they never physically moved out of the house. They never physically put the house back into community, and they never legally remarried. They continue to live as boyfriend-girlfriend for the balance of their lives. Husband passes away, and the wife rolls into an attorney's office to do the succession, and she discloses as everything that they own is being community property. Because in her mind, they were never really divorced. In her mind, they only did what the attorney told them to do so they could get into her retirement plan. Not in her mind did we actually get divorced and terminate our community property regime and remove ourselves from all these benefits. He had 5 brothers.
Oh.
He was estranged from 3 of them.
And guess which one showed up picking a corner?
Well, guess which one said, there's no way in hell I'm going to give you my brother's interest in that house. I just came into a windfall of a 1/5 interest in my brother's half of a house, and you just want me to give it to my sister-in-law that I don't like and have never liked? Ain't going to happen. Ain't going to happen. And I remember the lady telling me, but we really weren't divorced. We really weren't divorced. And I said, he never moved out. We never had a cross word. The attorney told us we were only doing what we had to do to get into my retirement plan. That's all we were doing.
How long did that relationship last after the divorce?
20 years before he passed. Are we a common law state?
Do we have it in this state?
No.
Not anymore?
Never.
Common law marriage?
Never.
Were we a common law state?
I know we're not a common law state, but I mean, there was never such a thing as if you live with somebody for
People
7
did
years.
that back in the day, yeah.
But it
They
was-
called
They
it that.
called
But it
it
was- it
that.
didn't-
Right.
Well, then,
It wasn't, you could have been with somebody for 30
And it
years,
was
never
not a
married,
and it wouldn't
they
hold up.
got their children or their
Come on.
mama, or you had nothing, you have no rights.
Well, I got a lot of ants that be in trouble.
All right. So here's the deal. As a closing attorney, I'm not this lazy attorney. Okay. So as the closing attorney, it's not my job to advise her, to consult with her, to correct the statements that her previous attorneys have given her. Because listen, unfortunately, we all have a tendency to do this. We all have a tendency sometimes in dealing with people to give them what we think is an explanation that makes the most sense for them, even though it may not be the legal explanation. So when they say, but we don't want to get divorced, and the attorney says, oh, you're not really getting divorced, you're just doing this to get into the retirement plan, without any real appreciation for the legal consequences of what they're really doing, or any advice that they need to go back and undo all this once you dip into your 401k, you know? So my parting words to her were, you really have to call your succession attorney. The lady that you hired to do your succession, you need to give her a call. And you explain to her that you were mistaken about the community nature of all these assets that were probated, and ask her what the next step is. And of course, that lady called me, and I had to fax her all the documents that came in our title work, showing the community property partition, showing the divorce, showing everything. And she says, oh, I feel horrible for this lady because she's got 3 brothers-in-law that just are not going to work with her. So she's going to be stuck in this house. Now, technically, she doesn't even have a usufruct over the other half of the house because it wasn't a community asset.
They can charge her.
They can charge her rent. They can force her to sell it. They can force her to sell the house to get their 1/5 of the 1/2, their 1/10 interest in this house. They can force her to sell it. Now, I don't get the impression that any of these estranged brother-in-laws are motivated to do that, but none of them are standing up and voluntarily relinquishing their interest in the house to her. They're going to sit on it until one day they get their money.
Because she had the marital contract.
Because she got divorced and never got remarried, and because her house was not a community asset. She and her husband still own the house 50-50. But they didn't own it in community, and therefore usufruct did not apply.
So if they had gone back 6 months later and remarried,
They'd be fine.
they're fine.
Yeah. There's a lot of things they could have done. I don't even know that they had to wait 6 months. There was a lot of things that they could have done to have avoided the situation that they're in. They were working under a misperception that they weren't doing anything but what was needed to get into their retirement plan, without a real appreciation for what they were actually
That
doing to
attorney
get into
really
their
did
retirement
it
plan.
justice.
And the sad part is, he's a very good attorney. The attorney that represents him is known in St. Tammany Parish as, and I'm not going to mention his name because I don't know his side of the story, but he's actually known in St. Tammany Parish as being a very prominent tax attorney, very successful, very prominent tax attorney. As far as financial guys go, he's one of the top guys. I find it hard to believe he gave them this advice. I really, really do. But there's no question, that they're suffering from the consequences of their actions related to that advice.
So they actually had a judgment of divorce.
Yep. You can't, look, when you want to get into your retirement plan, you can't play around. You've got to take it all the way to the finish line. Yeah.
Because some people do marital matrimonial
You
contract.
can get financially divorced though.
How's that?
Without getting, I know people who've been financially divorced.
Explain it to me.
That everything becomes separate. They're still legally married, but checking accounts are separate.
You can't get into your 401k on that basis. What you're talking about doing is just terminating the community property regime. And unfortunately, I've got a good friend of mine who's going through that right now. I would imagine we all have people who can't financially live apart, so they have to stay married for the sake of finances, but they're not really married anymore. But they want to cut off their obligations to their spouse's credit cards and things of that nature. So they just file a termination of their community property. They do a community property partition. They separate their obligations, and they say, you know, you'll be responsible for any credit cards you open from this point forward. I'll be responsible for any credit cards I open. We'll both be equally responsible for the house note, that kind of stuff. If that's what you're talking about, that does happen all the time. But that doesn't meet the criteria to qualify for a termination of your qualified retirement plan. You can't go dip it into your retirement plan to settle with your spouse because you just happen to terminate your community property regime.
Fraud?
Yeah.
Yeah.
I guess I just don't have a criminal mind, and I would never have thought to do something like that.
Well, I don't know that these folks thought of it either, but they had an attorney who told them that's the way to do it. Yeah, you're not supposed to do things legally that are for the perception of one thing to get the benefit of something else. You're not supposed to.
I mean, you're
But
sitting here telling this story, and I'm just going,
how's it work like that, Ryan?
no, I'm just thinking, you know, you do ugly, you get ugly 10 times worse. Karma.
Okay. Yeah. No, I can't argue with that. But it happens. People do that kind of stuff. All right. So we okay with everything up to this point about how it has to be an intestate succession. It has to be a community property asset in order for that usufruct to kick in as an operation of law. It also kicks in as an operation of a testament. You could leave someone a usufruct. Donna had a great example of a lady who left someone a usufruct who would not have otherwise gotten a usufruct under a conventional basis. Your daughter, her daughter, is not getting a usufruct under normal conventional circumstances, but that usufruct was created by the virtue of that juridical act. Okay? All right, so the Article 890, at the bottom of page 99, it says, if the deceased spouse is survived by descendants, the surviving spouse shall have a usufruct over the decedent's share of the community property to the extent that the decedent has not disposed of it by testament. The usufruct terminates when the spouse dies or remarries, whichever occurs first. Y'all remember my story about the evil stepmama that never told her stepkid she remarried? This is what's going to help you remember that. Ordinarily, a usufruct extends until the death of a usufructuary in the case of a natural person, or in the case of a juridical person, the earlier of 30 years from the effective date, or when the juridical person ceases to exist. The legal usufruct of a surviving spouse will ordinarily terminate at remarriage. Okay, so what is a juridical person? Corporation. So if I left a business a usufruct over something, there's actually a mechanism to determine how long that usufruct lasts. It's right there, 30 years. The legal usufruct of a surviving spouse will ordinarily terminate at remarriage. What you'll typically see, for those of you that are going to do this will work, you'll typically see the husband and wife who are still in the first marriage, who still have nothing but biological children from the first marriage. More often than not, they don't care if the surviving spouse remarries. Can you believe that?
Yeah, I don't care.
She doesn't care. You hear that, Dad? She doesn't care. So they more often than not, they don't care if the spouse remarries. You know, that's not what they're concerned about. Now, second spouses with children from first marriages, they do care, because they don't want that spouse to remarry and prolong their biological children from getting their share of what the will is being addressed about. No, Donna, you don't think so?
No, oh, no. I guess I just don't think that far ahead.
Especially if you got
No, meaning
stepkids
that
saying
when say it again about they don't want it prolonged.
Well, okay, so husband and wife are on second marriage or third marriage for that matter. And they both have biological children from previous marriages.
Okay.
And they've each chipped in to buy this house that's now the home. And they will often say, if my surviving spouse remarries, I want the usufruct to terminate, because I don't want my kids to be deprived of my interest in this property for as long as the surviving spouse should live.
Right.
If he or she gets remarried and gets on with their life, then give my kids their stuff.
Right.
Yeah.
And that's when you so what happens. You see trends. If you do will work, you see trends in what people want. We're not that all together different. And so you start to see people want the same patterns of things depending upon what their circumstances are.
Unless you marry somebody from another culture, and then it's all screwed up.
Yes, ma'am.
If you're married, I was thinking as you were talking.
Okay.
If you're married, second marriage,
Mm-hmm.
he has biologicals, you have biologicals,
Mm-hmm.
but you and he got married with a prenuptial agreement.
Okay.
You bought the house,
All right.
got a prenuptial,
Mm-hmm.
but you all had a good marriage.
Mm-hmm.
And you make a will and says, I want him to have the usufruct, but the children are still the owners. Could you do that?
Sure. Absolutely. Absolutely. And that happens. But you'll typically see if he remarries, then I want the usufruct to terminate, and I want my kids to have the house back. I don't want him living in that house with the new wife. With my kids having the stepdad and the stepdad's new mama living in their house. So they'll typically put a termination date on that scenario. But yeah, but they don't have to. If they're the kind of person that says, look, I don't care how many times he or she gets married, they can live in that house forever. My kids will just have to wait. They can do that.
Can you give them the usufruct, not only terminates with the remarriage, but terminates when they cohabitate for longer than with the same
You
person?
could. I've never seen it before, but you certainly could. I think it's hard to prove cohabitation. It's hard to prove it. Dina's making a face like she can easily prove it. They don't change their driver's license, that they don't voter registry. I mean, there's a lot of things that prove habitation.
It's no big deal. Why get mad?
Right? No, you're right. You're right. You're absolutely right. Okay.
Just curious.
Okay. All right. So, but this is where I thought you were going with this, Donna. This is the next part on page 100, that big paragraph. It says, a usufruct may be established for a lesser term or under a condition and may be subject to any modification by juridical act consistent with the nature of the usufruct. A usufruct is not heritable. The usufructuary may not transfer his right to successors, but a grantor may establish a usufruct of successive usufructuaries with the usufruct terminating upon the death of the last survivor. So what you'll see sometimes, I know where I thought you might be going with your example was, hey look, I want you to have use of the house, but for 2 years, dude, and then you got to move on and let my kids have the house. But I'm going to let you grieve for 2 years, but that's it. So you can always stipulate it for a lesser term. Now that last paragraph, that last sentence in that paragraph right there, where it says, "But a grantor may establish a usufruct in favor of successor usufructuaries, with the usufruct terminating upon the death of the last survivor." What does that mean?
That means you can give it to the heirs, and when the last one dies, then that's it.
Oh, we'll give it to them all at one time? Is that what you're saying?
Right, when the last one dies, that's it.
This actually says something slightly different.
Yeah,
It says,
keep
I give it
passing
to
it on.
Consuela, and when Consuela dies, I give it to Sanjanita,
Okay,
and when
so
Sanjanita dies, I give it to Jessica C. When Jessica C dies, I give it to Lorraine, and when Lorraine dies, it goes to Rebecca. When Rebecca dies, then it goes back.
You see that a lot in New Orleans.
You do? Okay.
It's those family homes.
Oh,
They
okay.
just passed on and passed on.
So the contrast in this paragraph is this idea that if Consuela gets the usufruct, she can't leave the usufruct to Sanjanita. She can't do that. You can't. The usufruct can't be transferred to a successor. Because you're not the grantor of the usufruct, you're the recipient of it in that example. As the grantor of the usufruct, I can leave it to successive usufructuaries.
You could
And so-
set it up in your testament that it goes boom, 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 boom.
Just
boom.
like I did it like that.
Okay.
Yes, sir?
Going back to that example of the husband and wife, the wife gets usufructs and
Uh-huh.
she gives it to her daughter.
Right. That's the Donna's
That's-
example.
But that's not,
She didn't get usufruct. And in Donna's example, she got the house.
Completely in a.
And we see that all the time, Dad. We see that all the time. Husband and wife come in, biological children from first marriages, they're on their second marriage, they're sitting at the table. I want to leave everything to my wife. And my wife says, I want to leave everything to my husband. And in the event that we both pass away, then everything gets split amongst our kids equally. My 3 kids from my first marriage and his 2 kids from his first marriage. Okay, y'all with me so far? So the contingent beneficiary is that the kids will come into their share after the second spouse dies. Donna's lady, after the husband dies, rolls into the attorney's office or the notary's office and says, I'm not real happy with this contingent beneficiary. When I die, I want my daughter to have the usufruct of everything I just inherited from my husband. And then when she dies, it goes that when she creates the usufruct, she names all the other kids the naked owners. So that when she dies, the other kids will come into their share.
Okay, now let's take it a little bit further.
Well, hang on just one second, because
Okay.
he's making a face at me like he's not done.
well, I still don't understand if you can't grant the, the usufructs
But-
on and on.
But she was the owner, because the husband dies.
Okay.
And now she inherits everything because that's what the will
Okay.
said.
Yeah.
Now the husband's
That's
counting
what I'm
on
saying.
her not to change the will, so that when she dies and her initial bequest can't be satisfied because he's predeceased her, that the contingent portion of the testament says everything gets split amongst the kids will go into effect. She ain't playing that. She went in, she changed it, and she says, my daughter gets the usufruct of my stuff because I just inherited my half and I just inherited my husband's half. And when she dies, the naked owners will get to split it.
Well, she couldn't have cut the other kids out completely?
She sure could have.
Okay, well, that's,
Okay, all right, so let's take a little bit step further. Okay, so mom dies,
Mm-hmm.
daughter's got this usufruct that now she doesn't want.
Okay.
What did she just say? I don't want it, let's split it up?
Sure.
Okay, that's all I want to know.
Yeah.
She can sell her usufruct.
She sure can.
So
Absolutely.
in the one that I gave you,
Right.
you had a husband and wife,
Mm-hmm.
biologicals from previous marriages,
Mm-hmm.
with the prenup.
Mm-hmm.
Husband gets the usufruct, children still own. Husband can roll in and say, you know what, I really don't like
The
that.
big difference between your example and Donna's example is that the husband only has the usufruct. In Donna's example, the surviving spouse actually inherited.
Inherited, okay.
And so the
Okay.
difference is that he only has a usufruct and he can't pass it on. In this particular scenario, she owned the property and she had the right to change the contingent beneficiary in her
Okay.
testament.
Oh, okay, that's a good, okay.
Did you like that?
I like
Yeah, Sanjay likes
Yeah,
that.
because
enough to
I,
still include his kids.
It's so nice of you to think of it that way, that she didn't want to cut the kids out completely.
Well, that's what I'm saying. That's
Yeah, but
what-
you're right. She could have. She could have said, "I'll leave every." And look, I don't know how you're going to handle it, but I handle it that way. When they come in and they say, "This is a contingent beneficiary," I always say, "You can't control what your spouse does after you pass away. We can do these wills, and they can say that, but if your spouse changes his or her mind, they can come in here and change it, and your kids can be cut out." Wait a minute, my kids could be cut out, and all of a sudden they start thinking, "This is something I really want to do." And I think as a notary, you kind of have a duty to explain to them what the next step could be.
Yes.
And in full disclosure, you know, I'm not trying to beat anybody out of anything, but I want you to know what's the worst case scenario.
Okay.
So her kids can only be the naked owners? His kids can only be the naked owners? I mean, I know she has.
In Donna's example, we're talking about Donna's example.
Right.
No, that's what Dad's saying. Dad's saying that, hey, don't fault this lady for giving her daughter the usufruct. She could have given everything to her daughter and left all the other kids out. That's what he's saying.
They're saying she's a nice lady.
Dad's saying she's a nice lady.
Right, but I would have wanted my
She's
children to
the
have a portion.
I agree with you. He's a little crazy. I agree with you. He's justifying why she's not a bad person for not cutting the other kids out, but she still cut the other kids out because it was their intentions.
Because right, they don't get it until after the daughter.
Yeah, but she's not got 5 stepbrothers hoping she dies.
Nope, you're right.
You know?
That's a different example, but look, and every situation's got to be evaluated for its set of circumstances. Exactly. There's no one brush that paints
I have
everything.
one more question.
Yes, ma'am.
I'm a little, okay, so if, in my example, I'm just trying to think.
Yeah, we've got the husband and the wife, the
Right.
kid from first marriages, and a
If
prenup.
husband doesn't pay mortgage,
Okay.
he has usufruct, he doesn't have ownership, so really, the children would have to pay it to keep
Well,
from
you
losing
got
it.
for me to answer that question, you got to tell me who signed the promissory note that the mortgage secures. I gotta have more information to answer that question.
The initial promissory, mom did.
All right.
So
So
children are owners, so children are really responsible for the mortgage because he only has usufruct.
Right.
So if he doesn't pay it, they would have to pay it, or he could lose it, and then they lose their portion.
right.
That's what you
So
were talking
we're gonna
about
talk
earlier.
about the expenses of the usufructuary and the expenses of the naked owner. And I think you're gonna find that that particular expense is the usufructuary's responsibility. And if the usufructuary chooses not to pay it, then the naked owners would need to step up to protect their interest in the property,
That's what I'm
but they would never have an obligation to pay it because they never signed the original promissory note, and they're not the usufructuary who's otherwise statutorily responsible for that expense.
And that's what you were saying about 30 minutes ago when you gave another
Right.
example.
In that
Exactly.
example, I was just trying to kind of put things into perspective, how where things are filed on your property have an impact on the outcome of those questions, and that we've got to pay attention to the public records and where things are filed. And so the purpose of that example was just to make sure that you had an appreciation for a mortgage on a property prior to the creation of the usufruct, that the property could be foreclosed on. That was the point. Okay? Where are we at?
I don't know.
All right, page 100.
Example.
45.
Okay.
Modification of usufruct. 545.
545. All right, oh, we kind of covered all that.
Yeah, that was
All right,
what
so
you covered in that.
in order for a usufruct to be valid, I'm on the top of page 101, and I'm below Article 547. It says, in order for a usufruct to be valid, the usufructuary must be alive, or in the case of a juridical person, in existence at the time the usufruct is granted. In the case of an inter vivos act, the usufructuary must be in existence at the time the act is executed. In the case of a usufruct granted in a testament, the usufructuary must be alive or conceived when the testator dies.
Ah. So here we come back to the conceived live person thing.
And we're going to talk about that in a lot more detail in a subsequent chapter. And the whole in vitro, we're going to talk about all that kind of stuff.
Oh, Lord, what about the embryo in the freezer?
Yes, we're going to talk about all that kind of stuff. But it says, in order for a usufruct to be valid, the usufructuary must be alive, or in the case of a juridical person, in existence at the time the usufruct is granted. If I leave a usufruct to XYZ LLC, and I die, and I leave that usufruct in a testament, and XYZ LLC doesn't exist, what is this saying happens?
It doesn't, then your usufruct doesn't exist.
And the usufruct doesn't exist. It says, in the case of an inter vivos act, the usufructuary must be in existence at the time the act is executed. So the difference between leaving it in a testament, leaving it in an inter vivos act, is that I'm doing this act while I'm alive. Inter vivos is during my lifetime. And I leave the property to XYZ LLC, and they're not in existence, the usufruct isn't created. But the difference between an
Page before is 544.
what's that?
The inter vivos and mortal clauses.
Oh, the inter vivos and mortis causa on page 544?
No. On Article 544. It's one page before, it's right in the middle.
Oh,
Five.
page 99. Robin's talking about page 99, guys. Article 544 in the middle of the page, methods of establishing usufruct, things susceptible of usufruct. Usufruct may be established by a juridical act inter vivos, that's during your lifetime, or mortis causa, which is typically a testament that's taken place at your death, or by operation of law. The usufruct created by juridical act is called conventional. The usufruct created by operation of law is called legal. Usufruct may be established on all kinds of things, movable or immovable, corporeal or incorporeal. All right. So back on page 101, the existence. So what we have is an inter vivos act where I leave something to an LLC that doesn't exist. The usufruct's not created. But the nice thing about that scenario is I'm still alive, and I have an opportunity to ratify and correct that transaction. What happens with a mortis causa transaction, you know, a usufruct that's created in a testament, is that the opportunity to fix that problem no longer exists. Okay. So in an inter vivos act, those transactions can be ratified. The usufructuary must be in existence at the time the act is executed. In the case of a usufruct granted in the testament, the usufructuary must be alive or conceived when the testator dies. So if I leave the usufruct to someone who has predeceased me, then it will be as if I never left them the usufruct at all. Okay. If I leave the usufruct to my unborn child, that child has got to be conceived at the point that I've passed. And there are all kinds of exceptions about the frozen egg thing. There's all kinds of exceptions, but we'll tackle that when we get to the chapter on that. All right, so it says, though it is a personal as opposed to a predial right, usufruct may be granted to either a natural or juridical person. It says the next line on 101, the usufructuary is required to cause an inventory of the property subject to the usufruct. The inventory is conducted by a notary public and is of the same nature and governed by the same procedures regarding inventory of succession property. Let's go to page 102. And it says, in order to protect the interests of a naked owner, the usufructuary is required to provide security equal to the total value of the property unless dispensed with by law or by the grant of the usufruct. So one of these examples we've been talking about all night about how, as a naked owner, I've got some reservations about, you know, letting my usufruct be reduced to something consumable because I could lose it. Now, in that example, I can't ask mom to get security, to post a bond, a performance bond that guarantees that she won't manipulate those funds and dispose of that. But in some usufructuary scenarios, it is okay for the naked owner to appeal to the court and demand that the usufructuary post a bond of some kind to guarantee that they'll be a prudent administrator of the asset so that we'll be there when the usufruct terminates. Okay?
Actually give a short example because I know we're all.
Well, you know, maybe in the example we were talking about, where it's the biological children from different marriages, and I leave the surviving spouse a usufruct, but for 2 years. Now, in that particular scenario, that's a usufruct. Unless I waive the requirement to post a security in conjunction with that testament, then I think that the biological children, my biological children, who stand to gain from the termination of that usufruct in 2 years, can go to the courts and ask the courts to ask that surviving spouse to put up a bond or security of some kind to guarantee 2 years from now that the asset that they're charged with the responsibility of maintaining will still be there, will still be in good condition, and will still be of some value to me. Okay. But your biological children aren't going to be able to ask the courts to put poor mom or dad on the responsibility of getting security or posting a bond. That's not going to work. There's got to be some sort of distance in relationship. So dispensation of security is kind of the example I was just giving Donna, which is Article 573. It says security is dispensed with when any of the following occur. A person has a legal usufruct. A surviving spouse has a legal usufruct under 890, which involves it being a community asset. A parent has legal usufruct under 891, or a surviving spouse has legal usufruct under 2434. Or a seller or donor of property under reservation of usufruct is not required to give security. So if I donated the usufruct of something, then they're not going to be required to give security because they received it by donation. Liability for repair on page 103 is kind of interesting. It says, during the existence of the usufructuary is liable for ordinary maintenance and repairs to the thing that is subject to the usufruct. Liability for repairs. It says the usufructuary is responsible for ordinary maintenance and repairs for keeping the property subject to the usufruct in good order, whether the need for these repairs arises from accident or force majeure. Force majeure is another way of saying by natural causes, by nature. The normal use of the things are his fault and neglect. The naked owner is responsible for extraordinary repairs, for keeping the property subject to the usufruct in good order. Whether the need for these repairs arises from accident or force majeure, the normal use of the things are his fault and neglect. The naked owner, okay, so
What is force majeure?
Hurricane
That's
Katrina,
nature.
yeah, things that you have no control over, that kind of stuff. The naked owner is responsible for extraordinary repairs. So this is the story I'm going to tell you to help you remember this. I have a client whose mom owned a shopping center in Washington Parish somewhere, and I don't know the shopping center, but it was a decent-sized shopping center. And she had like one nice-sized anchor tenant and a bunch of smaller stores. And she left the usufruct of the shopping center to her second husband, not my client's dad, but her stepdad. And of course, they don't get along. They were estranged. And he sends her a letter and says, according to my attorney, you're responsible for all extraordinary repairs as the naked owner, and there's a $15,000 air conditioner that just went out at the very top of the Anchor Stores building, and we're going to need you as the naked owner to pay for this extraordinary repair. Y'all with me so far? Okay. So she comes rolling into my office and she throws a letter on my desk and she says, I don't have $15,000. Exactly, can he do this? And I said what?
Yes.
No.
What? I said no. This is why I said no. Article 578. It says, extraordinary repairs are those for the reconstruction of the whole or a substantial part of the property subject to the usufruct. Everything else is an ordinary repair. Got to know the definitions of the terms we're using. So this is what happens. Extraordinary, a $15,000 air conditioner, that's extraordinary to me.
To me,
But it's not extraordinary by definition as far as the civil code is concerned.
it would be if a tornado came.
Any gain in the fruits of that shopping center?
Mhm.
It's
He
ordinary
shouldn't put money
maintenance.
with it.
It's ordinary maintenance by definition. So what happened was his attorney said, hey, the naked owner is responsible for all extraordinary repairs, and he must have thought to himself, $15,000 is an extraordinary repair, so he sends her the letter. So we sent a letter back, and we said, although we can't disagree that it might be extraordinary to you, it's not extraordinary according to the law. It says,
578.
extraordinary repairs are those for the reconstruction of the whole or a substantial part of the property. The repair of an air conditioner does not fall into that category no matter how expensive the air conditioner is. Therefore, we will not be making that repair. Therefore, you make that repair. We're going to stay on top of you as a naked owner to make sure you get it done. You've got an obligation to preserve my asset. So this is what happened. He ended up relinquishing his usufruct over the property. He could not make the repair and didn't want to get sued for the negligent management of the asset for which he had the usufruct
Because he's
of.
got an Anchor store in there that's sweating.
Exactly. He's breaching the lease.
Yeah.
He's negligent in his duties as the usufructuary of the property. And apparently he got the advice it'd be easier to give her the full ownership of the property and let her be straddled with the responsibilities of dealing with the air conditioner, let her be straddled with the responsibilities of dealing with the tenant and the lease issue, and just wiping his hands of it. So my client was thrilled.
Triple net leases.
Right, well, so my client, although she didn't have $15,000, was thrilled with the outcome of that scenario because she ended up getting the shopping center that her husband. Bless you.
Okay, can I ask a real quick question?
Sure you can.
Okay, now this is all of a natural family, let's just say, because we're talking about, say, husband dies, without the will, wife is usufruct over the house, and over time,
Bless you.
she doesn't make like the homeowner's insurance payment.
Mm-hmm.
And would that be considered negligent? Could the natural children sue her?
For not maintaining insurance?
That's
One
not
of them?
here.
Yeah.
Oh.
Yeah.
You have an
that's not here.
obligation to manage the property as a prudent administrator. Now listen, what we're trying to do is you're asking me for my opinion as to what a prudent administrator is. And
Right, I'm just
I
asking
can't say that the courts have held that a prudent administrator is one who pays the insurance. But I would imagine anybody that's in here that's a homeowner has homeowner's insurance.
Yeah.
So I think it's fair to say that homeowner's insurance is a prudent expense and it's a reasonable expense under the circumstances.
Okay.
And as the usufruct of the property, you failed to pay the premiums to maintain the homeowner's insurance, and my property is lost as a result of your mismanagement, yes, I'm going to be suing you.
But can you go back to I'm thinking about as people age and these insurance costs are like going nuts,
Yes.
right? And
Yes.
it comes to a point where they cannot afford the insurance.
Then they gotta move. Life sucks.
You still have an obligation to maintain the house. You still have an obligation to maintain the house, and if you can't afford to maintain the house, at no
Well,
point in
can
time
you-
under the law does the naked owner have to step up and supplement your operating expenses. Not the answer you're looking
Yeah.
for?
No, it's it's the answer. It's the
Yeah.
answer.
Yeah,
I mean,
there's not a scenario where the naked owner's got to supplement the operating expenses of the usufruct.
I just see so much, when we go on these listed
Yeah.
appraisals and it's crazy. All right, sorry.
Habitation, that's okay. Habitation is the second kind of personal servitude. It is a non-transferable right of a natural person to dwell in the house of another. It is created and extinguished in the same manner as usufruct. Unlike usufruct, the right of habitation will never arise by operation of law. So what they're saying is that no one's going to die and someone's going to end up with a right of habitation pursuant to a statute. It's got to be created in a juridical act of some kind. Like usufruct, it usually extends until the death of the person who's granted the right of habitation, but may be shortened in the juridical act creating it. I don't see this very much, but I do have a client who's got the black sheep brother, and the mama doesn't want the black sheep brother to not have a place to live, never held a job, never been much of anything, doesn't even cut the grass, and so she doesn't want to leave him any more interest in the house than she leaves her other kids. So she doesn't want to be unfair to her other biological children. So she has a testament that says that when I die, black sheep son has a right of habitation. Okay, so that he'll have use of the home, even though he won't have. Doesn't want to leave him the home because she can't guarantee what he'll do with it. Doesn't want to give him any rights greater than what his natural rights would be, but doesn't want his brothers and sisters kicking him out because he'll have no place to go.
So he gets to live there, but he can't do anything with it but live there.
That's exactly right, and he can't leave it to anybody else.
Can't lease it, can't sell it, can't
No.
donate it.
No. Page 104, that middle paragraph says, the right of habitation extends to the person's family even if he was not married at the time the right of habitation arose. So he can't do anything with it, but he can get married and move the wife in. And if she's got children, he can marry those that he can move them in too. And if she's got a mama that needs a place to stay, she can move them in. So it extends to the family. So it doesn't have to be the family he had at the time the right of habitation was created. It can be the family he comes to have after the right of habitation has been created. All right. Page 105, right of use. The right of use is a third kind of personal servitude. It confers in favor of a person a specified use of an estate that is less than the full enjoyment conferred by a usufruct. The right of use may also be used to grant personal rights to a natural juridical person that ordinarily only granted by predial servitude in favor of the owner of another estate. Thus, a right of passage may be stipulated in favor of a particular person or other than the owner of successor owners of an estate. So we've been talking all night about how personal servitude is run in favor of a person. This is kind of that quasi scenario where, let's say it is a driveway, but I'm only going to let this one person have the right to use it. It's not a charge on the property, it's a right that this individual has as it pertains to property.
But can it be recorded on the title of the property that that person has the right to use it?
If it's going to be perpetual, it has to be. Yeah, it's got to be in the public record. Page, yes ma'am.
I wanted to point out that this, back to this other thing, I've never seen it on the test, but I think it's an interesting statement.
Where you
It
at?
includes the servants of the family, back to,
She's on page 104, she's at subpart 12, which is right below Article 3506. It's a definition of family. Family in a limited sense signifies father, mother, and children. In a more extensive sense, it comprehends all the individuals who live under the authority of another and includes the servants of the family. It is also employed to signify all relations who descend from a common root.
I thought that
Someone
was.
comment.
I always thought that was very interesting.
A predial servitude is a charge on a survey, I'm on page 106 guys, is a charge on a surveying estate for the benefit of a dominant estate. The two estates must belong to different owners. It is not necessary that the estates be contiguous or even near each other as long as the benefit is derived from the servitude on the other. Now, I don't know of many examples that involve servitudes that do not involve contiguous properties, but you will sometimes see this, and it's not the best Louisiana example, but you'll see it in Alabama and Florida, where the people that are on the beach side of the highway can't build up past a certain point for the benefit of the view of the people on the non-beach side of the highway. There's actually a restriction or a servitude of sight or a restriction of height, and that's non-contiguous property. That's a non-contiguous property. I've got a client with a condo in Destin, and they've got this very funny shaped condominium complex, and it's been designed so it can actually kind of peek out and see a little bit of beach in between two other complexes, and nothing can go in that little bit of angle because it was designed with a servitude of sight line. So that's what they were talking about there. Otherwise, your more traditional predial servitudes are going to involve contiguous property. And I would think that any example that you might see on the exam is probably going to be an example that involves contiguous property. You're going to have a dominant estate and a servient estate in a predial servitude situation. The middle of page 106 says a predial servitude is an incorporeally immovable. However, the servitude cannot be separated from the dominant estate. The very bottom of page 106 says the use of a predial servitude may be limited to certain days or hours. Further, where the dominant estate is partitioned, the servitude runs in favor of each estate subdivided from the whole or the original dominant estate. Subdividing the dominant estate cannot result in replacing an additional burden on the serving estate. And so what they're saying is that if you've got, and I don't know any slides to show you, but if you've got a tract of land, and right smack dab through the tract of land is a servitude that accesses a piece of equal size in the back. And the piece of equal size in the back can only be accessed but through the servitude that runs through the first piece that borders a public road. Now with me so far? And then those properties are owned by two different people, and the people in the back of the dominant estate, because they get to cross the property of the serving estate where the driveway exists. And the guy in the back decides to cut the back piece up into 5 parcels of land. So what they're saying is that you can't put a greater burden on the front guy to give you 4 more servitudes to access the 5 pieces. You've got to figure out how to create access to those 5 pieces once you've crossed his property amongst that back piece only. So I can split up the dominant estate into multiple parcels, but I can't put a greater burden on the serving estate to give me access. Does that make sense?
So he'd have to keep that one road in and then build a road across.
That's exactly right. Think of it as being like a T, where it was always 2 rectangular pieces of property with one road that goes to the top piece. If I want to split up that back piece, I need to create a T from that road so that everybody will be able to come up the main driveway and then drive across the other driveway to be able to access their individual parcels.
Sounds like Pearl River.
You see a lot of that. You do see a lot of
Lake's
that.
like that. The main entrance of Briar Lake, that's a servitude. And you got through that one. Everything goes through that one entrance.
Could a servitude limit the amount of access or
Sure.
the traffic and the hours that, like it said in here?
Yeah, I did a closing for a guy one time who owned a lot in a subdivision, and he happened to own a 5-acre tract of land behind the lot. Just coincidence, he managed to come to own them both. And so he sold the house that he owned, and he reserved a servitude to cross the property that he owned to access the 5 acres in the back, because that was the only place it was accessible. And things were clicking along just fine. And then one day, the people who were buying the house from him said, now wait a minute, you're going to be building a house back there. You're going to have big cement trucks, you're going to have delivery trucks, and our yard's not that big, and these cars are going to be driving through our property to get to your property. And they said no, we're not going to buy the property. We don't want it. That's not what we bargained for. And so they came back and they said, for the 6 months that we're building the house, from certain hours only, you're going to permit certain kinds of traffic. After that 6 months is up and the cement trucks and the delivery trucks have all come and gone, the servitude will be limited to strictly access for personal purposes only. So they not only restricted the kind of vehicles, bless you, not only restricted the kind of vehicles and the time frames for which they could operate, they also limited the time frame for which that even existed, and then reduced to something else entirely. And when the people saw that and they got comfortable with it, they went ahead and they bought the house.
Could they also say that the land behind it couldn't be subdivided?
They could have, they didn't.
They didn't?
Yeah, but they could have.
Because it's 5 acres.
It's a different kind of restriction. One at the very end of this chapter, if we make it so far, you're gonna see building restrictions as a kind of servitude, and that would be like a restrictive covenant or a building restriction that the 5 acre tract never be subdivided any further than that. And it would be something you would impose upon the property so that the people that owned it, because if it was a personal servitude, then in theory, I could sell that 5 acres to someone else who could split it up.
Yeah.
So it's got to be a predial servitude, something that runs with the property, so that no one that ever owns that property can split up that 5
So
acres.
most of your gated communities and all of that are running off of what?
They have to.
Servitude.
Because
like
if
you were
it,
talking about over by Oak Harbor.
Yes, ma'am.
Over that way.
Oak Harbor, absolutely. It has to be a private servitude, otherwise you've got no right to block it off. If it's a public street, I have the right to access it. So it's got to be a private servitude where the person who has the right to access has got a key and a contractual right to be there, something that came through their deed when they bought their property. Okay? All right, kinds of predial servitudes. In the bottom of page 107, there are 3 types of predial servitudes: natural, legal, and conventional. Legal and natural servitudes may be altered by the agreement of the parties as long as the public interest is not adversely affected. In such cases, the servitude will both be conventional and either legal or natural. Page 108 says, natural servitudes arise from natural situations of estates, such as the servitude of natural drainage arising between estates with different elevations. They are different from legal servitudes discussed below, that they are not created by the operation of law, but are merely recognized by the law as arising from the natural topography of the land. I bought a piece of property a long, long time ago and built a house on it. And the person that was building my house came out and graded my property so that the water on my property would run to the ditch in the front yard, just as a subdivision plan had called for. And in doing so, the neighbor who was next to me, whose house faced a different street, he was on a corner and his front door faced one way, so I actually had his backyard as my side yard. His water drained onto my property, and because of the way the swale had been cut in on my property, water was backing up in his backyard. He came knocking on my door one day and said that I had a duty to fix that problem because he drains onto my property and then my property drains to the street. You've got to get your contractor out here to fix this problem. Well, my contractor was my grandfather, and he said, that dude's out of his freaking mind. And so I called the planning, and they said no.
Sounds like a legal opinion to
Right.
me.
So they said, so I called parish permits or planning, whether they said no, that the natural drainage in that subdivision required that his property drained to the ditch on the side of his house. He did not have a right to drain to my property and then force me to take his water to the ditch. So when I knocked on his door and shared that with him, he said, I've been doing it for long enough that you've got to do it now. So he tried to use prescription as a basis for saying, but he hadn't been there long enough and it didn't work. Now
How
look,
long would it take for prescription?
I think it would have taken him 30 years.
Wow.
I think he would have had to have had 30 years of that activity because he doesn't have a title that allows him to do it. He doesn't have any outward possession of it. So I think he would need a long, long time. So, but he tried to make the argument that he had squatters' rights on this drainage issue because it was the natural topography of the land. Planning says there is no natural topography. It's being created with the development. There is no natural topography. So no, that didn't work.
What a way to meet your neighbor.
And you
Yes, what a way to meet the neighbor.
I was about to say, you invited him to the barbecue.
No, there was no invitation to the barbecue. So that's an example of a natural servitude. Legal servitudes are limitations on ownership that arise by operation of law for the benefit of the general public or particular persons. Examples of legal servitudes are the obligation to keep a building in repair so that it doesn't cause damage to passerby or neighbors, and the obligation not to use property in a manner that deprives the neighbor of the ability to enjoy his own property. Common walls and enclosures on page 109. Give me an example of what a common wall is.
Townhouses.
Townhouses, where you've got like 3 units, and all the units, the unit in the middle shares a wall with each of the outer units, and the outer units share one wall with the middle unit. And so that's going to be your common wall. You're also going to have common fence lines. You're going to have common roof lines in those township situations. So that's what they're referring to when they talk about the common walls and enclosures. Rights of passage, bottom of page 109. It says the owner of an estate that has no access to public road or utility may claim a right of passage over neighboring property to the nearest public road or utility. He is bound to compensate his neighbor for the right of passage and to indemnify his neighbor for the damage he may occasion. What they're talking about there is a term you might be more familiar with. You've heard the term landlocked? That's what they're talking about, a landlocked situation. I'm landlocked on my property and someone owes me a right of access to a public road across their property. It's not a freebie. It's not something that I can ask them to give me and not compensate them for it. And I've got to compensate them not only for the value of the lost property, but also for any damages they may incur as a result of it. For example, the servitude is going to run across their driveway. I'm going to be driving across their driveway in the middle of the night, that kind of a thing. Affirmative and negative predial servitudes on page 111. Flip it over and let's go to the bottom. I want to talk about negative predial servitudes because it's a concept that I think is important. It says servitudes are either affirmative or negative. An affirmative servitude is one that gives or grants a right to the owner of the dominant estate to do some act upon the servient estate. A negative servitude is one that prohibits the owner of the servient estate from doing some act upon his estate that will benefit the dominant estate in some way. Basically, a servitude that allows the owner of the dominant estate to exercise some right upon the servient estate as if he were the owner, such as a right of passage, is affirmative. A servitude that prohibits the owner of the servient estate from exercising some right otherwise as an owner would, to, like for example, to erect a wall or a building which blocks his neighbor's view, is a negative servitude. Go to page 112 where it says apparent and non-apparent predial servitudes. It says servitudes are also either apparent or non-apparent. An apparent servitude is one that is perceivable, such as that road or drainage ditch. So in the example of the positive or the affirmative and the negative, that road that people are using to cross, that's apparent. I can see that road, okay? But the servitude that is negative, the one that says you can't build a fence, how can I see that?
Right.
Right? So where I may not necessarily need to see that road servitude, that passive servitude in the public records, I have to see that negative servitude in the public records or it doesn't exist. So what if Don and I've got an arrangement? Don, you're just not going to build a fence because I want to be able to see the street. I'm just not going to build a fence. And we never get a document signed and we never get it recorded. But we have a deal. There's no question we have a deal. What do we have? Nothing. Because
and if I sell, unless it's recorded, the people that can come in and buy. And I can't do this. You can't say, well, hey, look, I'm going to sell you my house, but you can't build a fence because Brad, I have a You say, okay, fine.
You could say that. The people have no obligation to honor it.
That's what I'm saying.
Yeah.
You say, okay, that's fine. I won't build a fence.
And the first thing you do is put up a fence and you got to look at it. Right.
I'm the buyer and I say, Don, I want to put up a fence, and you want to say, yeah, go ahead.
All right, so examples of predial servitudes. All right, let's look at establishing predial servitudes on page 113. Predial servitudes are established by title, destination of the owner, or acquisitive prescription. Acquisitive prescription is what my neighbor was trying to pull on me with the whole drainage thing. Establishment by title means by a juridical act between the owners of the dominant and serving estate, the same manner in which immovable property is alienated. Destination of the owner on page 114. I want to talk about this before we call it a night because this is important. Destination of the owner on page 114 is a relationship between two estates owned by the same person that would be a predial servitude if the estates were owned by two different persons. If the estates are no longer owned by the same person, a servitude that is apparent will arise automatically. So let's say in that example I was given earlier where I own that big piece in the back and I've got the piece in the front with the driveway that accesses the piece in the back. That's the example I was using earlier. So let's say that same example, we've got this big square piece of property and my house is way in the back and I access it by a driveway from the main public road. So I come off of a major highway, I turn onto my private driveway, I drive all the way back on my private driveway to my house. Well, as long as I own the entire tract of land, that driveway is not a servitude, it's just my driveway. But I decide to cut off the front piece and I want to sell the front piece to someone, I want to be off the road because I like my house in the back, it's nice and quiet, but I want to sell the front piece. What they're saying is that that driveway will become, by destination of the owner, it will become a servitude. If we don't capture it juridically, it will become a servitude because we all knew as we were negotiating this deal that I can only get to my house through that driveway. So that's what they're talking about, destination of the owner. It's the idea that something may not be a servitude while it's owned by one person, but if it gets split, then it becomes a servitude by virtue of that transaction because that's the only way the second piece is accessible. I had a quiz. We haven't got time to go over it. You want to just do it?
hand it out, or you want?
Well, they won't do it.
No.
Yes, I like doing and looking up the answers. I do.
Definitely, this is a
Do it like you want
terrific
to.
study guide. I wouldn't get it last week, but I'm gonna work on this.
All right. So we'll hand them out.
Next week is 9, and 10.
No. So what we'll do is we'll hand them out. You guys do them, and we'll cover them in the first couple minutes on Thursday. And
Okay.
it's going to be on servitudes, but we don't have a lot of time with it because donations is just as long as servitudes.
Y'all want to pick one up on your way out?
I think it's good testable material, you know,
It's very good.
because you can really throw in some crazy facts and steer people in the wrong direction. Mama,
Are we gonna get the answers?
Sanjanita wants to know if you're turning this in. Jessica C wants to know if you get the answers.
Okay,
So that we can send us.
I have the answers. I will email them to you.
No, don't email it until I finish mine. I'll cheat.
Well, just don't open the
Don't
email.
cheat. Don't open the email.
You don't have any more copies? Put them over there.
Send it to us.
All right, I'll email y'all the
You're
answers.
dealing with grown-ups here?
How many of y'all plan on attending study group tomorrow?
I'm a scoop.
Oh, you have
Tomorrow's Wednesday, isn't it?
Sorry, Saturday. Saturday.
What time? 1 o'clock, right?
1 o'clock.
Is that on the syllabus?
Yes, it's on the syllabus that we start on Saturday.
Study What time?
1 o'clock.
Right here?
Right here.
y'all answer questions like for people who have no idea? Y'all answer questions?
Yes, that's what I did. Are you that lost?
Sure.